The NLRB handles about 25,000 cases each year. Only 1/3 of the complaints are found to have merit, and of these cases, 90% are settled. Many charges are dropped after a contract has been successfully negotiated. Other cases are dismissed by the NLRB because they're trivial or because the NLRB does not have enough time to handle them. The NLRB faces a constant challenge to improve its efficiency since the full procedure from charge to complaint to hearing by a law judge to board ruling normally requires a full year. An unfair labor practice is any action by either the union or management that is prohibited by law or NLRB rulings. Every case originates in one of the regional offices as a charge or petition that has been filed by an individual organization. Unfair labor practice charges can be submitted in person or by mail, and they must be filed within 6 months after the alleged practice was committed. The regional offices of the NLRB investigate the charges by assigning a field examiner or an attorney to take written statements and affidavits from available witnesses. Regional offices try to dispose of the cases informally through withdrawal, settlement, or dismissal. If a case is not closed by one of these informal methods, a formal complaint is issued by the regional director to the general counsel. The general counsel may dismiss the case. This is the preliminary NLRB investigation and settlement agreements formal and informal procedure. Before complaints or a case goes before the full board, a formal hearing is held. An administrative law judge conducts the hearing according to the rules of the evidence and procedures of the United States District Courts and then issues a decision. Any party that disagrees with the judge's decision may appeal to the 5-member board of the NLRB. After the NLRB issues a decision, a dissatisfied party may appeal to the Federal Court of Appeals and then to the Supreme Court to review the case. This process may take several years. In a typical year, about 50% of the NLRB's rulings are appealed and approximately 85% of these rulings are upheld. Many of the unfair labor practice charges submitted to the NLRB arise from improper campaign activities, such as interference, restraint and coercion, threats of reprisal, promise of benefits, solicitation of grievances, restricting employee activities, surveillance and interrogation of employees, inciting anti-union activities, discrimination for exercising rights, discipline or discharge for union activity, and no solicitation rules.